This is the matter of State versus Turner. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsels, are you ready to proceed?
Yes, Your Honor.
Yes,
Thank
Your
you.
Honor.
Well, thank you. Appellant, please identify yourself and let me know how much time, if any, you wish to reserve for rebuttal.
I'm Mark Rademacher, Assistant Public Defender for Elizabeth Turner. 5 minutes for rebuttal.
Good morning, Mr. Rademacher. Senior Associate Justice McDonald will be our timekeeper. Can you see him?
Yes.
Thank you very much. He will let you know when there's 5 minutes, 3 minutes, 1 minute, time up. Thank you.
Okay. The state's case at trial involved an agreement between, excuse me? Am I not loud enough?
I can hear you, sir.
Okay. The state's case at trial was that Mr. Turner falsely told the victim, Bouffard, that he needed money to bail out the defendant. She gave him the money. They left. They spent it on drugs. They came back. They did it again. And the defendant admitted to police that she was in on planning this. Then hours later, in the middle of the night, between 12 and 1 a.m., they return home. The Turners are in the kitchen speaking with the victim, Bouffard. The defendant got up and left to go upstairs to watch television, and shortly thereafter, a fight broke out between the Mr. Turner and the female victim. The state's theory was that they were arguing about the bail larceny, that Bouffard wanted proof that he had actually spent the money on bail, and there may have been a threat on her part to either go to the police or have them kicked out of the house. The state claimed that tied the murders to the bail larcenies, which are larceny by false pretenses. And the defense at trial was, she was in on the larceny by false pretenses, the bail scheme. She had no knowledge that her husband was going to kill the female victim and her son when he came to the defense of his mother. The son thereby becomes part of the use of force involving the bail scheme. So her defense was, I didn't know he was going to do this. I had no part in this, his plan to kill the two victims and then steal money. Now, the problem here is that she engaged in the larcenies after the murders, which on its face is something fairly incriminating. However, she presented expert testimony on battered woman syndrome to explain this otherwise incriminating behavior was not all that it seemed. The rub in the courts, yes.
Chief.
Justice Dario.
Do you dispute, Mr. Rademacher, that there's any evidence of the that the fight was over between the victim and the husband? That the fight was over the bail money? Was there any evidence about that, or you think that was just state speculation?
No, there was no direct evidence. Nobody heard what was being talked about.
Well, but did anybody testify? I think there was an informant. There was a guy that helped them sell the stuff later, or was in on it. Did anything come in through him about what the fight was over, or nothing?
Well, he referred to two remarks. One, at some time in the past, she had said, I want to put rat poison in the food. He also said that she regretted asking her husband to kill the victims.
Okay, but you don't think even through that gentleman, and the state can tell me otherwise, but that there was any evidence about they fought over the bail money?
It's all circumstantial. I mean, the proximity in time, the fact that several weeks earlier, the defendants, the Turners, had stolen money from a safe in her house. She had gone to police. They were in process of getting an arrest warrant for her. She had asked them to leave, and they didn't leave. I think in that context, it shows that this bail fraud was the last straw for her. And it was the state's theory that the force was used to prevent their being detected and arrested. I think that's a fair inference. I think it's uh, what the state argued to the jury on several occasions, that the bail larceny uh, was what started the argument and led to their deaths and the looting of their house. It's my position that a larceny by false pretenses can never be a predicate for a robbery. And the reason for that is that there is a consensual transfer. The victim is not coerced into giving up her money. She's just lied to and defrauded. And it the larceny ends with the transfer of the money, or at the very least, when they leave the scene with the money, and certainly by the time they spend it. The larceny is over. They come back and get in an argument over the money. The Mr. Turner doesn't want to be kicked out of the house. He doesn't want to be arrested. And, in a rage, so to speak, he grabs a knife off the kitchen counter and begins stabbing one victim and then the second.
I guess what I'm asking is if you, and you don't have to admit this, but I think you may have just admitted it, that take it back, feel free to. If it is a fair inference that they fought over the bail money, then why is it so clear that the larceny is complete? I mean, that's going to be Mr. Weller's theory, among others. I think that then they're using force to, give me the $100 back kind of thing. And they're not going to give the $100 back. And that leads to force, and that leads to the killing. Why is that wrong?
Because the use of force has to be motivated by a desire to take property, money, and get away with it. And in the case of fraud, well, the whole reason why he lied to her was to avoid a confrontation, and he's worried about getting, identified as having lied to her. Well, when I say it's a fair inference, I mean it's a reasonable inference. You could infer maybe it wasn't over that, but it's reasonable to make the inference that the force was used to get her money back. But too much time had passed since the larceny had occurred for it to be connected with the force. And this proper characterization of the error in this case is that it was constitutional, and that the appellate court employed the incorrect standard for determining harmlessness when I labeled it constitutional.
Thank you. Justice Khan.
Thank you, Chief. Counsel, I have two questions, two separate areas two separate questions. One is, you raised this as an instructional error claim, but in fact, the affirmative response by trial counsel to the court around the issue of including an instruction on larceny by false pretenses, counsel repeatedly reassured the court that they did not want the court to change its charge, that the charge was correct. And specifically, it's not even an implied waiver, it was an express waiver. So now here you're raising it as an instructional error based on how the state argued its case. How is it an instructional error? And then I have a follow-up question to that.
You're right. Defense counsel said, I'm happy with the court's charge. At that time, the larceny by false pretenses language was not in the charge. The state was trying to get it in the charge. And on at least 2 occasions, they had the copy of the court's charge. We had a rectification hearing to identify what charges they were talking about. And the false pretenses language was not in it at those times. It was only.
But counsel, I'm sorry to interrupt you, but maybe I misread the record, but I thought the court specifically asked about that subsequently, and counsel once again said no, that counsel was fine with that part of the charge, specifically that part of the charge. Did I misread? And I'll stand corrected if I misread the record.
Well, the issue came up on 3 occasions. The first 2 times it wasn't in the draft. But the court came out, announced its decision, I'm going to put it in. And then the final draft has it. At that point, he had lost. There's no point to objecting. He had argued that it shouldn't be put in, and the judge disagreed.
I thought there was an affirmative quote in the record from counsel saying they agreed, but maybe I'll stand corrected. I'll review the record more closely. Gets me to my second question, which was you started off conceding that a murder followed by theft, okay, could be qualify as felony murder. In this case, as I understood the record, your client's statement was that when she heard the fighting or the argument, she came downstairs and she observed her husband stabbing Mr. Perkins, the son. And she said at that point, she thought the mother was already dead. And then she went in the room and saw that she was motionless and dead. Otherwise, she would have gotten up to help her son. So the record seems to suggest he killed the mother and then killed the son. He was sleeping on the couch. Did I read that also wrong?
Well, she heard a commotion downstairs, came halfway down the stairs, and saw her husband stabbing Perkins. She assumed because you didn't hear the mother, she wasn't there, that she had already been killed. And her husband told her to go upstairs and threatened her with the knife if she didn't leave immediately. At that point, all she had seen was that Perkins was being stabbed. She assumed the mother was already mortally wounded.
And there's nothing else in the record to suggest that the mother was killed first, mortally wounded, when the son is overheard saying, "Not my mother"?
I think that the son has already seen that his mother has been stabbed, and he's, it's like a spontaneous utterance.
Okay. So let me ask you this. There were 2 charges of felony murder. And the second charge appears to be as it relates to Mr. Perkins. He had nothing to do with the larceny by false pretenses. So do you concede then that the felony murder, at least with respect to Mr. Perkins, relates to the fact that they took his moped and some of his other items and sold it and pawned it off for drugs?
No.
Why couldn't the jury infer that? And that'll be my last question.
Okay. I suppose they could infer it. The problem is we don't know if they did infer it. Perkins gets involved in the larceny by false pretenses when force is applied and he tries to save his mother. At that point, he's killed on the state's theory, killed during the course of the larceny by false pretenses because they're using Mr. Turner is using force to get away with it. As I argued in my brief,
I want to say, counsel, thank you for answering my questions. You concede that the larceny by false pretenses was never charged as an underlying false larceny or robbery in this case, correct? Other larcenies.
Right. There was no count involving false pretenses. It was inserted into the language of the robbery.
But there were other larcenies there were other underlying larcenies and robberies charged, just not the larceny by false pretenses, correct?
Yes,
Okay, so the state based other larcenies and robberies as charged those substantively as part of the underlying felony murder. Would you agree with that?
I would, the robbery elements and counts were fatally ambiguous. They alleged both that it's a regular larceny and one by false pretenses. And we don't know which theory the jury accepted.
Well, I'm not talking about the theory. I'm talking about the charges. There were standalone robbery and larceny charges, correct?
Yes.
Okay, I am going to end. I said that was my last question. I notice I'm going to refer back to the chief because some of my colleagues also have their hands up. Thank you, Attorney Rademacher.
Thank you, Your Honor.
Justice Keller.
Thank you, Chief. Good morning, Attorney Rademacher.
Good morning.
Now you concede theoretically that if the predicate larceny was the stealing of money and gift cards and other items of property after the stabbings and the purse, that was a legally valid theory if there was enough evidence for the jury to infer the elements of that particular kind of felony murder, correct? You're not conceding that the evidence was sufficient to prove that, but if there was enough evidence, if someone found there was enough evidence for the jury to infer that they killed the two victims because there was a plan to steal whatever they could get out of the house as fast as they could, that would have been legit, correct? That would be a legally valid theory, correct?
If they had proof that the defendant agreed with her husband to kill the victims and loot their house, that would be a valid felony murder theory. But they didn't have the evidence that she agreed with her husband to kill the victims and loot the house.
All right, well, your opponent argues otherwise, but let me ask you, you're claiming that the appellate court got the standard wrong because you're saying that felony murder based on a larceny by false pretenses is a legally invalid theory, but couldn't you actually have a felony murder if, let's say someone duped me out of some money and then instantaneously I realize I've just been duped and I try to grab my money back and they stab and kill me? That would be a felony murder, and the larceny by false pretenses would be the underlying felony, correct?
I disagree with that. As soon as the person realizes they're being defrauded and asks for their money back, now you have a common, ordinary larceny. So,
The beginning of a new larceny. Is that what you're saying?
well, I don't know if you can cut it up into two larcenies, but that was the appellate court's hypothetical. What if the victim learned that the defendant was sitting out in the car and that she had just been duped? At that point, if she asked for her money back, it's an average everyday larceny, not a larceny by false pretenses.
But the appellate court agreed with my hypothetical, correct?
Right. And that's why they were wrong based on what I just said.
Thank you.
Thank you. The critical to the argument of appeal is that the instructional error was constitutional error, where larceny by false pretenses is followed by the use of force to escape with the loot. A robbery may occur, but it is based on a simple larceny. And here the judge authorized the jury to convict based on a larceny by false pretenses, and that's just legally impossible. And we don't know if the jury went that easy route because the defendant had admitted that she was in on the planning of the bail larceny. The only issue was whether it contemplated the use of force to escape detection. But she vehemently denied that she had any foreknowledge that her husband was going to kill the two victims. Indeed, she was very fond of Perkins and got along with him very well. Why would she want her husband to kill him? And this whole thing seems unplanned. He grabbed a knife off a counter. They got in an argument, and which led to the killings. All the while, my client is upstairs watching television. Yeah, I mean, this is not a sufficiency of the evidence claim, but my point is there were two competing theories about whether she was involved in a scheme to kill the victims and then loot their house. And there's no way of telling from the verdict in this case which way they went. The standard for this type of constitutional error is set forth in, I think it's Cody M., which relies on a Supreme Court decision, Hedgepath. And the analysis of the harm in this case, or the harmlessness in this case, should proceed as follows. You look at other counts of the information to see whether they have the same element as in the larceny by false pretenses. You look to see if they are based on the same evidence. Yes.
This is Ecker.
Sorry, Chief, I don't know if my virtual hand is working, so I made the effort to use my real one. Counsel, just a couple questions. I mean, as I understand it, the appellate court actually found here, hypotheticals aside, they found that it was error to include the larceny by false pretenses in the charge, right?
Yes.
That's what the appellate court said. Can you help? I think it's just the topic you were about to address, so maybe I interrupted you for no reason. Can you help me figure out whether this is a situation where it was a legally valid theory that was factually unsupported on the one hand, or a legally invalid theory that was factually supported, I guess, or whatever, but a legally invalid theory on the other? How do we distinguish between those two with particular reference to this, this case?
Well, you look at the elements of a larceny by false pretenses. There's no wrongful taking away of the property, which, when combined with force, would make it a robbery. Here, there's a non-coercive transfer of the money to the defendant, and certainly by the time he spends the money, it just can't be the predicate for a robbery.
So I guess that's why you're arguing that it really doesn't matter, that even the appellate court or Justice Keller's hypothetical is not persuasive, because if it were, it would become a question of factual insufficiency as opposed to legal insufficiency. Is that why you're arguing that there can never be a
Right.
larceny by false pretenses under this?
A larceny by false pretenses does not have the element of larceny that could serve as a predicate for murder. It's just the charging of it makes no sense. And here there was facts that could have supported this invalid theory. The judge said, hey, it's up to you if it's a larceny by false pretenses and whether it force was used to commit it. The juries were given the authority to convict on that theory. And that it's critical here to recognize that the defendant denied involvement in the killings to loot the house. She admitted involvement in the larceny by false pretenses. So the state had a stronger case on this invalid theory than it did on the valid one. But the only way that this verdict could be saved is if the robbery counts omitted the false pretenses language. If they did, then you could say that those robbery counts prove that the jury did not rely on the invalid theory. But the problem here, is, of course, is that the robberies are fatally infected by the same false pretenses language.
Chief, you're muted.
Sorry about that. Justice Khan.
Thank you, Chief. Counsel, I have a couple of questions. Let's assume the court had not used that instruction. Are you saying that the state would have been precluded from introducing evidence of the prior larcenies to explain the overall nature of their relationship and behavior?
Yeah, it could have been admitted for that reason.
Okay, so the evidence would have come in even without the charge because they would have laid out what sort of the nature of their relationship and what had transpired before the date of the murders themselves, correct?
Yes.
Now, you started earlier, you said there are two competing theories. Can't tell which one the jury believed. And earlier in your argument, you said, well, the state utilized the subsequent thefts and sales and pawning off and taking the car and selling the car. It was a weak conduct. And you indicated, well, but she had this battered women's syndrome defense. Isn't it possible that the jury just didn't buy her defense and thought she was part and parcel of their agreement?
That's a reasonable inference. It's not the only inference, but.
And there is no requirement in felony murder. There's no requirement that the parties agree to murder the person they're intending to steal from. In fact, isn't the point of the statute that there is no such agreement? And then in the course of or in flight from a larceny or in the course of a robbery or in flight from or in attempting to conceal a robbery, one of the participants winds up killing someone. So there's no requirement that there be an express agreement between her and him that they were going to kill them.
No.
Is there?
It's just an agreement to use force and recognizing that it could lead to murder or it may not.
Does it have to be the use of force, or it can be just something, a larceny that turns into a robbery that turns into then a felony murder?
Yes, I mean, it could be based on a threat.
Okay. All right. I see your time is up, but I also am going to yield back to the chief because I noticed two of my colleagues, Justice McDonald and Justice Keller, have their hands up. Thank you, Chief.
Thank you very much. I'll do this in order of seniority. Justice McDonald?
That's okay, Chief. He's already a minute and a half over, so I don't want to take up his time. Never mind.
Thank you. Justice Keller?
I can ask my question of the state's attorney,
Thank you very much.
Chief. Thank you.
Okay.
Appreciate it. Mr. Weller?
Thank you, Your Honors. May it please the court, my name is Ronald Weller. I represent the state in this matter. I see that Justice Keller has her virtual hand up, so I will pause.
Thank you, counsel.
Thank you. Good morning or good afternoon. Good morning, Attorney Weller. Mr. Acosta at some point said that the defendant admitted regretting that she told her husband to kill one of the victims at least. Did he put a time frame on that? Do we know exactly what point in time she was admitting that she had told him that?
So I'm just looking at my facts quickly, Your Honor. If you just give me 1 second, I can see if I can find that. I know this was right after the murders. Acosta, the defendant, and Claude Turner were upstairs using drugs. And at some point, Turner said here it is. They were getting high, and then the defendant said she regretted telling Turner to kill Bouffard and Perkins. So the regret was as to both of them. That was on page 79 to 80 on the April 1st transcript. And so I guess your question is, do we know what time frame she told him she was going to wanted them dead? And I don't think the record shows that, Your Honor, definitively. Nor
right,
does. Okay, thank you, Your Honor. So, Your Honors, I had three arguments in this case, right? I have a waiver argument. I have an argument that the reference to larceny by false pretenses was not improper, given that it reflected the state's theory of prosecution of a continuing crime spree. And I have a harmless error argument. On the waiver, Your Honor, I will say this. This claim started out in the appellate court as not just an instructional claim of error, but there was a due process claim of error. There was a claim that the court abused its discretion for even allowing the state to make this argument. So there were other claims of error associated, and I think there was even a hint at prosecutorial impropriety for arguing this. And so in that case, I put forth several different standards of review. But now, Your Honor, the claim has crystallized to one of instructional error, and that's how the appellate court ruled. And in my brief, Your Honors, and Attorney Rademacher agrees, there were three instances where the defendant said she didn't have a problem with the instructions. One of them was on April 21st, which was when the jury instructions started. And at that point, my understanding is that the language of larceny by false pretense was already in that charge. And even if it wasn't, during the final charge, there was no objection by the defendant on that ground. It's not like the defendant said, my goodness, you put this larceny by false pretenses language in, which I wasn't aware of. So the defendant made it clear that she was not objecting to the charge. In fact, on April 19th, during a charge conference, and this is on page 166 of the April 19th proceeding, the court said, are you contesting the charge or what's proper in final argument? And the defendant said, final argument. I have no objection to the charge. And basically throughout the proceedings, there was no objection to the charge. And I understand, that waiver should not be employed lightly. But here, the parties were talking about this issue specifically. And the objection wasn't that you can't charge this, Your Honor. It was that the state shouldn't be allowed to argue it. So that's the basis of my waiver claim. I see that someone has a hand up. I will pause.
Thank you, counsel. Justice Keller, then Justice Kahn. Justice Keller, you're still muted.
I forgot to take my hand, unraise my hand. I'm all set.
Okay.
Thank you.
Thank you. Justice Kahn.
Thank you, Chief. My question, I think you addressed it in your last statement, which was my understanding was there was a discussion particularly about this issue of could the state argue the larcenous, could the state use as part of its theory the larcenous, ongoing larcenous behavior and the larcenous by false pretenses. And the court said, is it their argument that you're objecting to or the actual definition of that larceny in the instruction? And the affirmative response was no, not the instruction, it's the argument. And so you answered my question, which there's no ambiguity that what the court is asking there is about that particular portion of the charge. It's not like a waiver by an implied waiver or an omission. That's specifically what they were talking about, that area of the charge, correct?
Your Honor, to be fair, I'm not sure the record shows that they talked about the larceny by false pretenses language in the charge. What they were talking about was utilizing larceny by false pretenses as part and parcel of this continuing.
Okay, so are you retracting what you said earlier, which was that on April 24th, there was a discussion with the court and the court said, are you objecting to them making the argument or you're objecting to the charge? And you said, defense said, no, I don't have a problem with the charge. I have a problem with the state's argument, arguing it in closing. Is that what you're saying? Did I mishear you?
No, Your Honor, that's exactly what happened, Your Honor. And okay. You don't have to take my word for it. If you go to page 166 of the April 19th transcript, you'll see that that's what was said.
Well, I did, and I thought that that's what I read, but
Yeah.
that it was that particular part of the charge, which is why I asked your opponent. But all right, thank you, Chief.
So, thank you, Your Honor. So I do, and I see that another justice has a hand up.
Thank you, Justice Sacker.
I wanted to make sure not to give you any breathing room there, Attorney Weller. So this, my question is on there's some cases cited by the defendant in the reply brief that you didn't get an opportunity to respond to. Hedgepeth, Skillings, the recent Cody M out of this court, I think that the chief wrote, as I recall. But in any event, do you have a response to that line of cases as they relate to this, the legally invalid versus factually insufficient point?
I do, Your Honors. If I could just summarize so, Your Honor, one of the reasons I said that this was not constitutional as far as harmless error goes is because in State versus Chapman, that's what this court said, as the Supreme Court did in Griffin versus United States. In those cases, they say where there's no facts to support a theory that shouldn't have been given to the jury, any error is harmless and it's not constitutional, okay? That's different from saying that there is a theory that's invalid, right, that shouldn't have been given to the jury, but still there's a harmless error that goes along with that standard. And I think that's the Cody M, Hedgepeth, and the Zant versus Johnson, I believe, case that I cited. So there's two ways to get to harmlessness. Now, this is my quick, succinct view of those cases, Your Honor. I believe that Cody M, having read that, is really directly on point. It's a direct appeal involving a claim that the jury charge was inaccurate, where the court gave a charge on a theory that it shouldn't have. And the court basically said, in its ruling in Cody M last September, that the common thread in all of these cases, Hedgepeth, Brecht from the Supreme Court, is that there could be a finding of harmlessness if the jury necessarily found facts to support the conviction on a valid theory. Okay, now, I didn't cite Hedgepeth, Your Honor, just because, to me, Hedgepeth is a habeas harmless error case. And I didn't want to conflate, and I think it's actually harder for a defendant in a habeas case to make the case. So the test in Hedgepeth is substantial and injurious effect on the jury. But I really think that goes to habeas cases, although this court did cite to that standard in Cody M. But the bottom line is, Cody M makes clear that if there's a valid theory upon which the jury rested its verdict, then there's no harm. In this case, we know for a fact that the jury rested its verdict of larceny by force on a valid theory. How do we know that? Count 4 was the only larceny charge in this particular file, and it only applied to the monies and things taken after the murders. We know that everything taken after the murder certainly was a larceny by force. The defendant concedes that because you kill people to get them out of the way to make it easier to take the money. That's a larceny by force. So we know that the jury made a finding of larceny that was for which force was associated. So we know that the jury in this case rested their verdict on a proper ground.
So help me out right there. I don't want to interrupt. I just have a question right there, which is, how do we know that the murder is tied in? I mean, I assume Mr. Rademacher would say that happened after the murder. Right? It happened after the murder, and therefore that robbery doesn't demonstrate that she was in on the murder, or that it was, am I making any sense at all?
Oh, yeah, yes, you are, Your Honor. And I think my answer to that would be that that for felony murder, the predicate felony, in this case, the robbery, somebody has to die in the course of and in furtherance of the robbery. And in my opinion, that murder was in course of and furtherance of the robbery, to which they had agreed. Now, the defendant, I know Mr. Rademacher, and I know there were some questions oh, I'm sorry. I noticed the judge has a hand up.
Finish what you're saying in just a second.
Thoughts.
Yeah.
Thank you, Your Honor. I know there were some questions about sufficiency of evidence, but I want to remind the court, we're not here on a sufficiency claim. We proved, and the jury found, that the defendant was involved in the robberies, right? Which meant that she intended to deprive these people of their possessions and do so by force. We also know that she was convicted of conspiracy to commit robbery. And so we know that they agreed beforehand that force would be used to get this property. There was no dispute of that. We know from the facts, Your Honor, that the defendant had said numerous times she wanted to use rat poison to kill these people, and that at some point prior to this, she had told Claude Turner to kill these people. So we have evidence, Your Honor, of an agreement to use force to get this property. And that was sort of the state's theory all along. And that's how I answer the question. And by the way, this started, way before the murder, right? This started with the safe, where they broke into her safe and they stole money from under her pillow. And it's just, that is why I believe the state wanted the bail scheme mentioned, because it was part of an ongoing larcenous crime that finally of the link. So that's my answer, Your Honor, to that. I know.
Thank you.
Mr. Well, I missed the last sentence you said. You broke up, and so I didn't hear what you said.
Oh, I'm sorry, Your Honor. Well, the last point that I made was that this all started with the safe being broken into, right? And then this money was stolen from under the pillow. And then it continued, and then the bail scheme. And then it continued after these brutal murders and to selling everything to the pawn shop and then selling the Lincoln Town car. That is why the state wanted this continuous larcenous ongoing crime spree theory to be put before the jury. And that was our theory. My point, Your Honor, is we know for sure in this case that the jury rested their verdict on a valid ground, because we know that the larceny in count 4 applied to all the takings after the murders. And we know that the count 2, the felony murder with respect to Perkins, and count 9, the robbery with respect to Perkins, involved monies that were taken after the murders, because Perkins had nothing to do with the bail scheme.
Okay, thank you very much.
Thank
Justice Doria.
Okay, so let me just make sure I understand on at least count 4. Maybe the point about Perkins and it being after the murders makes sense. But count 4, if I'm looking at it right, and this is in your appendix, right? A12. I'm sorry, A13. And it's value of the property exceeds $2,000. Why is it so clear that is after the murder?
Right. Thank you, Your Honor. I'm glad. So it's clear because of this, Your Honor. Number one, when the trial court charged on count 4, the trial court referred to all of the items stolen after the murders.
And didn't mention the bail scheme.
Did not mention the bail scheme at all as to those items.
Because you'd agree with me that, I mean, the way that the information is drafted and the way your theory is that this was one continuous crime spree, and that could include the bail. I mean, you've got dates about, late June to early July 2000. That could capture it. But you're saying that the charge cures all that?
So what I point about the continuous larceny, Your Honor, is that's why the court included larceny by false pretenses as an example of larceny, because it was pursuant to this entire ongoing conduct. But as far as count 4 goes, Your Honor, I agree with you. If you look at it, you look at it and say, well, I don't know if it applies only to the items taken after the murders, which were clearly larcenies by force. But you do know it because when the court charged the jury on count 4, it referred to all of those items taken after. And
so maybe that trumps, but isn't that in conflict with, the theme of your brief was this is all one continuous thing. And I take it that that's the way you argued it to the jury. You're just saying that it's clear enough from the charge that the jury's not going to be confused that they could do the false pretenses as a predicate to the felony murder.
My point, Your Honor, is even if the jury did do that, even if they said for count 4, the larceny by false pretenses might be included. And I will mention, the court didn't mention larceny by false pretenses in that count. But even if the jury could think it's included, there's no way the jury would have said that this felony murder and robbery, which needed a larceny by force, right? There's no way they would have said that was a that was the only larceny that they used to convict for murder and felony murder. They would not have only used the larceny by false pretenses. And that's the only way the defendant can show harm, is if we know that the jury only relied on an invalid theory. If we know that the jury also relied on valid larcenies, there's no harm. And by the way, Your Honor, count 4 charged the value of the items over $2,000. The bail scheme was $100. So they
Yeah, but
could
if it's all one continuous, you got 100 plus the robbery of the safe and all of that. I mean, I take it that's what you don't want to be particular about it in your charge. And so it's all, cash is fungible. It's all more than $2,000 or property.
And that's why, Your Honor, I had argued that, and I see other judges have their hands.
Yeah, I'm done. You can answer my point. Yep.
But that is why, Your Honor, that we charged this as a continuing theory. We didn't break this out into separate larcenies. We looked at it as an ongoing scheme, of which the bail scheme was part of it. But we know that even if this court says the bail scheme shouldn't have even been mentioned, that it wouldn't have made a difference because it was not there's no way the jury rested their findings solely on the bail scheme. That was never our theory of prosecution, and that's not what the charge said. I see the two judges have their hands up.
Yes, Justice McDonald and Justice Kahn.
Thank you. So I understand your argument, but some of it is very hard to process. And it almost appears that the theory of the case was developed after all of the evidence was in, because it's hard for me to understand how stealing from the safe was part of a robbery where the murder was committed at a long time afterward. I mean, it just seems like a stew of stuff rather than a coherent theory. Is that
Your Honor? No, can I answer, Your Honor? That's an excellent point, and I may have given you the wrong impression. The robbery of the safe was not part. The robbery of the safe was done in like April, and it was a totally separate information. Okay, that was not part of this ongoing larceny. The jury could have recognized that her plan was to steal from them all along. But as far as the ongoing continuous larceny, it started with the bail scheme and ended with everything being sold to the pawn shop. So okay,
that's not what you said earlier. That's a modification of what you said.
Right, and I think I don't think I'm being inconsistent, Your Honor. I think I just maybe didn't articulate myself very well. The point I was trying to make is the jury could have said, hey, this, when determining what her intent was, whether she agreed with Claude Turner to commit robberies, they could have looked at this safe incident saying she started stealing from them a long time before. But that was not part of this second information involving the continuous larceny, as was the sale of the Lincoln Town Car was a completely separate information. So I'm not saying.
So let me say, so in your continuing course of larceny theory, the safe is not included and the Lincoln is not included.
That's correct, Your Honor, because they're two different information.
So the bail scheme is included, and the Wii station and the TV and the guitar or whatever the instrument was.
Yes, Your Honor.
Okay.
Guitar, yes, Your Honor.
So as to the murder itself, is the extent of the state's theory that she intended for use of force to be used against the victims, her statement that she wished somebody would use rat poison on her? Is that the inference that would allow for the fact that she intended her husband to stab them to death?
There's actually three things I would say, Your Honor. One is the rat poison comment. Two is the comment, I should have never told Claude to kill those two people. And the third inference is, as soon as the bodies were were dead, as soon as they were dead, these two victims, she started rifling through the purse, took money, took the Lincoln Town car. All of them got into the car and got high and then started pawning off these items. I think all of those things, Your Honor, gives rise to the inference that she had agreed. And again, there's no sufficiency claim that she had agreed that with Claude Turner to use force to take the money to support the drug habit. That was our theory.
Okay, thank you.
Thank you, Your Honor.
Justice Khan.
Thank you, Chief. Counsel, I'm trying to understand the sequence of events. As I understand it, she had a settlement of $13,000. She used some to pay bills, put $7,000 under her mattress, then saw the money was missing, then used the safe. Then when she went on vacation with her friend in Vermont, came back, the safe was broken and all the money was gone. She reported that to the police. That all happened in April, presumably, or a month earlier. Then, as I understood it, correct me if I'm wrong, they come up with a scheme to say that the defendant is in prison and the husband needs $50 to bail her out. They get the $50 from her. They buy some drugs. They decide, she tells him, go back to her and tell her it's actually $100. She goes back, he gets another $50, and that all of that is happening in the space of the same day. And then they come home and or at least I thought that was all happening within the same day. The son's asleep, and then he gets into an argument with the mother downstairs. Is that? Yes. And then I thought the larcenies, or what they took after they were dead, was Perkins' moped, like
Yes,
money from her purse to buy other drugs.
Yes.
The Wii system and some other things, not just the three things you mentioned, right? There were more things than just the guitar or the three items you mentioned. There were several items, correct?
That's correct, Your Honor.
Okay.
So I would.
So the larceny by false pretenses starts the same day or the day before this? When does it start in relation to the murders?
Your Honor, I would disagree that you were confused about the sequence of events because you've just laid them out perfectly. The safe incident was a couple months before. The larceny by false pretenses, the killing, and then the rifling through the purse and getting the car keys was all done within a matter of hours.
And the statement and the statement to Mr. Acosta about I should not have told them to kill her, not the son, but her, that was also that same day, correct? He testified. Yes. That's when they were getting high upstairs while the dead bodies were downstairs. Is that correct?
Right, within hours of the murders.
Okay, so now that I understand what you claim the sequence is, let me get to my final question, which is, had the court not included the definition of larceny by false pretenses, would the state still have been able to argue? And just so you know, Justice McDonald put up the 5-minute sign. You might have missed it because you were listening to my question and looking away. Had the court removed that definition from the start of its instruction, would the state nonetheless have been able to argue this is part and parcel of the same conduct? It's sort of what informs the jury about the context of how this started.
Yes, Your Honor. Okay. If the court had left that language out, we still could have used, and I think Attorney Rademacher agrees, we still could have used that incident to bear on intent and the agreement for purposes of the conspiracy. Attorney Rademacher's position is the court shouldn't have used that language. Now, my first argument is, of course, it was consistent with our theory, as Justice DeOria had sort of alluded to, of a continuing, ongoing larcenous crime spree. And that's why that part was in the charge. But my question is, even if Your Honors think it shouldn't have been in the charge, based on Cody M, which is really on point, and the cases I cite, the Zant case in the Zant versus Stevens in the U.S. Supreme Court, that If we know that the jury rested its verdict on a valid ground, then there's no harm. And here we know that the jury didn't rely on the bail scheme by itself to find the predicate force needed for the robbery and the felony murder. We know that because they found the defendant guilty of larceny of items taken immediately after the murders, which were clearly part of the robbery and felony murder.
Thank
So,
you.
Thank you, Your Honor. I
Thank
see
you,
other.
Attorney Weller. I see other questions and I
Thank-
don't want to
thank
take
you.
up the time. Yield back to the chief. Thank you.
I see, Your Honor, that two justices have their hand up.
Yes, counsel, sorry. I keep forgetting to unmute. Justice Ecker, then Justice Keller.
I didn't see who was first, Justice Keller. I'll try to be quick. Mr. Weller, was the jury ever charged about a continuous course of conduct idea, or was that just in part of the state's argument, or did they make a finding of that? And my related question is on aggregation. I believe that there's case law that says that if a jury's going to aggregate different items that were stolen as part of a larceny, that they have to, the jury has to be told, you can only aggregate if you find it's a continuous course of conduct. I don't know in the charge. Maybe it's there. I just didn't check.
Your Honor, I know that there was, to answer your first question, I know that there was a continuing course of conduct language in the charge because the defendant objected to the charge on that ground. That was the only objection after the final charge. So there was a continuous course of conduct language in the charge. And the court, when ruling on this, said this is a factual question. I'm going to leave it to the jury. As far as the aggregate, that's an excellent point, I think, because we sort of, I believe, and I can't hold me to this, Your Honor, but I recall seeing somewhere that there was a mention of an aggregate, and I think it was in the larceny, in the count 4 of the larceny. I believe if you look in count 4, you'll see this aggregation of thefts. Thank you, Your Honor.
Thank you.
Was my time up? If my time's up, but I see Justice, oh, it's not.
Justice
Okay.
Keller.
Justice Keller.
Thank you. Justice Keller, please.
Thank you, Chief. Attorney Weller, do you disagree with the defendant that the larceny by false pretenses was a legally invalid theory, but factually supported?
No, I disagree. I think if anything, it was a legally, did you say, Your Honor, legally valid but factually?
Yeah, do you believe that that to use larceny by false pretenses as a predicate for the felony murder robbery counts was legally invalid?
I see my time is up. Would you mind if I answered your question?
Please
Your
answer. That's fine. Please answer.
Yes, my view, Your Honor, is with the appellate court that larceny by false pretenses is a legally valid theory. Okay, but there was insufficient evidence of force associated with that larceny by itself to rise to the level of a robbery. So that's why I used State versus Chapman by saying the jury would not have relied solely on the larceny by false pretenses or the bail scheme to elevate it a larceny with force, because there was no force associated with that larceny by itself. The only way force gets associated with that is if you consider the state's continuing crime spree theory. I don't know if that answers your question. If you have another, I'd be happy to try.
Probably just confuses me more, but I mean, your opponent's been saying that it's impossible to commit larceny by false pretenses in the course of a felony murder. You don't agree with that?
I don't. I actually kind of thought maybe that was the correct view, but when I read what Judge Levine wrote in the appellate court, I think that he's right. You could have a larceny by false pretenses where immediately after the trickery, the victim realizes what's going on and tries to take the property back, and there's violence. I think that could support a robbery with the predicate larceny by false pretenses.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you, counsel. Your time is up.
Thank you, Your Honors.
Mr. Rademacher? You're muted, sir. You're still muted. Still muted.
All right.
Thank you.
The one thing I wanted to point out here is a problem the state had at trial is that they didn't have credible evidence that the defendant agreed with Mr. Turner to kill the victims. The only evidence of that came into Acosta, who was a readily impeachable witness, and he was not to be believed because nothing he said about what the defendant said was corroborated by anything. In fact, at trial, they had to use his hearing and probable cause testimony to put in the statement about she felt bad about having them killed. He didn't remember that at trial. So if Acosta is taken out of the question, it's a very close case as to whether she had an agreement that they be killed.
But why is he taken out of the question? You said if Acosta is taken out of the question.
If he is not believed, all right?
But what if he is?
Well, if he is, there's still a question there, but it's a closer one. But here, you need to know with certainty that they adopted the correct theory. That's what Cody M is about. It's not a matter of whether it's likely or not likely. It's a matter of whether it necessarily follows that it's a logical conclusion that they rested it on a valid theory. And we just don't have that here. I mean, count 4, the larceny count, includes monies. That encompasses the $100 that was taken during the bail scheme. And at the end of the day, the issue in this case is whether the defendant was convicted of a non-existent crime, and that is a quintessential due process violation. And a final point, at the last few pages of my reply brief, I go through the sequence of events about the charge. We had a lengthy charge conference about this, where a number of, like 4 or 5 different copies of the charge were put into evidence. And if you look at it carefully, you'll see that the first 2 times it's not in the charge. He says, I don't want it in the charge. The third time, they're talking about the felony murder charge and the in course of language. And he said, that's okay with me. Your language on the course of a felony language is okay. So at the end of the day, the state cannot prove that the jury necessarily found or relied upon the valid theory of larceny. And all his arguments relate to, well, it's likely, 90% sure, or whatever. But he's convicted she is convicted of a non-existent crime, and the state cannot prove it harmless beyond a reasonable doubt, and the defendant is entitled to a new trial on the felony murder and robbery charges. If there are no questions, I'm done.
There is a question, Justice Khan.
Thank you, Chief. My question follows up on Chief Justice's question to you. You're saying, well, forget Acosta, he was impeachable, but his testimony came in, the jury could have believed him, but there was other evidence that would corroborate Acosta's account. Wasn't there evidence that your client wrote something to someone when she was incarcerated, also expressing regret for the killings? And wasn't there also evidence that the jury could infer that Acosta's testimony was credible by your client's own conduct? She spent a week with her husband after the murders. She had time presumably alone because some of the items she pawned off herself, and left the state to go to Baltimore with him, and was using drugs while the victims' bodies lay decaying in the house. So couldn't the jury infer from all of that conduct that, in fact, she was part and parcel of this plan and went along with it? Because another person, they could have rejected her battered spouse defense and thought she could have gone to the police at any point if she really had the regrets. Couldn't the jury have corroborated Acosta with all of that evidence?
Well, Acosta has the same problem of sticking with the Turners in the days following the murders and helping in the looting of the house. But yes, the jury could have gone either way on whether she was involved in the murders on a felony murder theory. But that's the problem in this case. We don't know for sure, and we have to know for sure that they only relied on the post-larceny and murders in the post-larceny. We can't say that with the degree of certainty necessary to find this it was a harmless error. Thank you.
Thank you, Attorney Rademacher. Thank you, Attorney Weller. We will conference shortly after this matter, after a brief recess. I want to thank everyone involved in this virtual hearing. It's the way we've been able to meet our constitutional obligations. So I appreciate you doing it this way, and sorry for any of the inconveniences that the technology is currently causing. But we appreciate your help. With that, we are adjourn until tomorrow morning.
Thank you, Your Honors.
Thank you.